First sale doctrine, and why should we care about it? I'm going to spend the next 4 minutes discussing that. I'm Angela Langlotz, trademark and copyright attorney. I go live here on weekdays to discuss trademarks and copyrights. If you have trademark or copyright questions, drop them into the comments below and I'll answer them on a future live video. Don't forget to like and subscribe so that you get all my newest content. So we've been talking about alterations to shoes lately, and I wanted to spend a little bit of time talking about the first sale doctrine in terms of trademark law. Now, the first sale doctrine says that anyone can resell a product that has the trademark on it, and that's not a violation of the trademark owner's rights. There are some limits to that. I'm going to talk about it in a second. So the first sale doctrine says, hey, if you buy a product through authorized channels, you are allowed to sell that product again, and the trademark owner can't sue you for trademark infringement because you're reselling their branded product. Now, like any rules, this has some limitations that are pertinent to what we've been talking about lately. The limitation is that if the reseller makes some sort of material alteration to the product that changes some essential quality of the product, then that's considered a trademark infringement. So we've been talking about athletic shoes and alterations made to athletic shoes. For example, the Satan shoes with the blood and other liquid in the midsole. We also talked about the Jesus shoes that made similar alterations. Now, when a reseller makes an alteration to a trademarked product, the trademark owner has the right to sue for trademark infringement if the alteration somehow alters the material quality of the product. For example, with the Nike shoes are made with an insole that, provides cushioning and some other properties perhaps to the shoe. So if you alter the midsole by injecting substances into it, you may be altering the quality of the shoe. Well, why does Nike care about that? Because Nike has a vested interest in making sure that the quality of the shoes sold by the reseller is the same as the quality of the shoes that left the Nike factory. So Nike wants to make sure that they protect their reputation, which has been built over a few decades for manufacturing quality products. And if Nike were to allow resellers to alter the shoes and then resell them, and the alteration could affect the performance or safety of the shoe, then that could put Nike's reputation at risk, and they have the right to sue for that and stop the reseller from making those sorts of alterations. So this is what we were talking about, especially with the Satan shoes. Not only did the reseller of the Satan shoes inject some things into the midsole, but they altered the appearance of the shoe in order to make it look like Nike was supporting Satanism, and this was very damaging to Nike's reputation. You had people threatening to boycott Nike and never buy Nike products again. So this sort of material alteration can do significant damage to a trademark owner's reputation and the way people view their product and their business. So it can be very damaging. So if you are a reseller, don't make any material alterations to the product because you may be sued for trademark infringement. I'm Angela Langlotz. I go live here on weekdays to discuss trademarks and copyrights. You can find me online at TrademarkDoctor.net. I'm also on YouTube at video.TrademarkDoctor.net/YouTube. I'm also on Facebook at facebook.com/TrademarkDoctor. Ask me any trademark questions in the comments below the video. I'll answer them on a future live. Don't forget, like and subscribe.